going on, mate? Got to get it where you can get it, no matter what it is.
What this?
You stupid bastard.
Gary! Gary! Gary!
All week long. Bang, 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 and howdy, everybody, and welcome to We Got a Case. That's right, nothing but cases. For the next hour or so, we're going to jump around from one courtroom to the other. Unless we found something we really love, we'll stay with that. We're going to see an old friend right here. This is the old Double Dirty. We're not going to check in with them quite yet because one of my new favorite judges is sitting on the bench right now. He's I had to rewind this a little bit, but today in Florida, if you didn't see the lady that we had on the other day, go back and watch. I think it was Wednesday's show. I'm going to jump back over to Florida and see our good judge.
Can I say something, sir?
These are merely out.
Counsel, do you want your client to say anything?
Not right now, Mr. Davis. I don't want you to put anything on the record that may cause an issue
listen,
for us.
she didn't even press charges. Why is there a charge against me if she's not pressing charges?
Sir.
The state has to have a victim in the case. There's no
Sir.
victim. So why am I even?
Lawyer.
Hang on a moment, please. Sir, the state
It has to have a victim. She just told
Victim-
y'all she didn't press no charges. So why am I
Just a
charged with
moment.
domestic violence? She
Sir, if
just
you'll
said
hold
she
on.
didn't press charges.
Sir, a victim has a right to request that charges be dropped, but a prosecutor has
She
the
just told y'all she
responsibility.
didn't
Just a
even
moment,
press no
sir.
charges. So who
I've
pressed the
heard that.
charges?
Quiet,
Please let the judge
sir,
speak.
or I will conclude this hearing. The point that I'm trying to convey to you is the state has the responsibility to determine whether to agree with a victim's request to drop charges or not. In this case, the state has not agreed,
Oh, yeah.
and that's their authority to do that. So under the circumstances, at this time, the motion is denied.
Understand, Judge.
Well, I'm glad to
Yeah,
see
but
that.
That's without prejudice to
For a
fulfilling
second,
the
I thought that
obligation
was
of case
shoot.
plan, which can be done separately.
She just told y'all she
Long as-
didn't press no charges though. That's, I mean, it's
Sir,
my
I just
constitutional
explained
right.
it to you.
said that
The state filed charges and they're pursuing them.
Shane and
So
Rick. good to
who's
see
the
ya.
victim in the case?
We need a return court date.
Dave, I will go for
Same
Lisa.
alleged victim, they'll have to prove the case up if the case
Hey,
goes through the court system.
Mr. Trucks, can you put in for a motion for a speedy trial, please?
Rodney.
On my case, a motion, I have a motion right here that I was supposed to put in if they would have brought me to court. I want a motion to demand a speedy trial on this case. This is ridiculous, man. I done been locked up 13 months for a
Okay.
case
Your Honor,
she
can
didn't
he
even
be instructed to
prosecute me
speak
on.
with his attorney at a different time?
There's
We'll talk to
our
your
good
attorney about
friend.
that.
She's
Make that
on
decision.
cam today.
Yes.
There's
Can
some
you come and
important
see me today, sir? This is ridiculous, man. She just
13
told y'all
months.
she didn't even press charges.
Can we?
All right.
GBU as well.
I
Nancy.
want to put in a motion for a speedy
Just a
trial.
moment, sir.
On,
There's
on,
no button that can be
on,
pushed.
Your attorney has heard that. He is here. We've all heard it, sir. Your attorney has the ethical duty to talk with you because of the
And a
implications
motion
of
to
that decision.
dismiss, and a motion to dismiss this escape charge. This is ridiculous, man. Y'all are doing
It-
some, this is against my constitutional rights.
All right, sir, that'll conclude this.
Can y'all
hearing.
remove him, please?
Uh-oh.
Judge, would it be possible to call a hearing at a turn?
My goodness, he come out of nowhere.
Who's that?
This
Oh.
is Mr. Hoffman for Mr. Cassidy's case. Nicholas Cassidy.
Are you in the right courtroom?
I was
I
giving
don't
the
see
Zoom in
that
for,
case.
Uh-oh.
it's not 21-1369 CF,
He botched it.
CFMA, no?
Which judge are you supposed to be in front of?
Co-counsel Mr. Delvilar gave me this information, so.
He's botched it.
Judge,
This
you
is
should be in Judge Stevenson's courtroom. You're in the wrong courtroom.
Judge Stevenson?
Yeah, I'm Terry Terrell. I'm presiding for Judge Clark today. I'm a senior
Okay.
judge.
You guys wouldn't have to know
Terry
Judge
Terrell.
Stevenson, do you?
Look at
Yes,
this
sir.
guy.
Okay.
You can contact his judicial assistant.
All
Sorry
right.
for that confusion, sir.
Sorry about that. Bye-bye.
Well, he just bust in,
Thank you.
threw everything
right.
under the
I've
bus.
got one more matter if I could.
Go ahead.
Marquise Player, come on.
Who's your client's name, please?
Marquise Player, this is case
Marquise
22
Plea.
CF 1821, Judge. We've got a motion for a bond reduction that's set for this morning. Player, yeah.
Plea. My boy Plea's good.
Aggravated battery with a firearm.
Yes, sir.
All right. Any witnesses?
I'm just going to take some brief testimony from my client.
Sir, if you'll raise your right hand to be sworn, do you swear affirm testimony you give will be the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
All right, state your name for the court, please.
Marcus Player.
Okay, and you're the defendant in the case that we just announced here moments ago?
Yes, sir.
All right, and what is your bond currently in this case?
250,000.
Okay, are you able to make that bond? Is
Yes, sir.
anyone in your family able to make that bond?
Yes, sir.
Let's talk briefly about your situation. Where are you currently living prior to being incarcerated?
In Tillsburg, Alabama.
Okay, and who do you live with there?
That's my mother.
Sir, if you talk up a little louder so I can hear you.
I said I was staying in Tillsburg, Alabama. That's my mother's house.
So you don't currently live in Bay County, but you're a resident of
See,
Alabama.
Carol.
Yes, sir.
If the judge decides to modify your bond, do you have the means to come back and forth to court at every court appearance this judge may want to see you?
Yes, sir.
And how would you do that?
I will come back and forth with my mother, my granddad, my family, any family member. They show up to court every time I come to court.
Okay, so you've got family that's more than willing to bring you back and forth should you need to appear,
Yes, sir.
even if your presence is waived at future proceedings. If the judge decided he wanted to see you, you would be here.
Most definitely.
Okay. Have you ever failed to appear in court before?
Never.
Okay. Is this your first felony charge
It was my first charge ever.
of any kind?
Any kind.
No prior record?
Ever.
Okay. If you're released and you return back home to Childersburg, are you able to find employment there?
Yes, sir.
Okay, and can you maintain that gainful employment full time?
Yes, sir.
All right, and would
Less
you be
complicated.
able to
Good to see.
abide by any restrictions that the court places on you if you're released?
Yes, sir.
Do you have an amount that you believe that you and your family might be able to post if he lowers the bond, but still has a monetary bond in place?
Like 50,000.
So maybe with the assistance of a bondsman, you and your family could post a $50,000 bond.
Yes, sir.
Okay,
What was the amount he said?
50,000.
50,000, Judge.
He's at 250,000 right
And,
now.
Again, obviously, this is a serious case. It's going to take some time, but you're going to stay in touch with our office. You've been good about it so far. We
Yes,
haven't
sir.
missed any telephone appointments.
He's been in jail. Of
Nothing
course
further
he
right
has.
now, Judge.
Questions? All right. Other witnesses?
No, sir.
State have any witnesses? All right. State's argument.
Yes, sir, Your Honor. We believe that the bond amount in this case is appropriate. The allegations in this charge is that this defendant got into some sort of verbal altercation with a victim that was here in Panama City. But he tried to gain access or get into the victim's car. And in the course of that altercation, that the defendant pulled a gun and shot the victim twice in the abdomen, which also then led to the victim crashing his vehicle that he was in. It is important, I think, to know, and then of course the defendant and whoever his co-defendant or co-suspect is then fled from the scene or went back into a motel. The defendant is also not from this area. He's not here locally, doesn't have ties to this community. So we believe that the amount that's currently set is appropriate, taking into consideration the seriousness of the charge, the danger to the community, and the fact that he doesn't have local ties to secure his attendance here.
Assuming there's a 10-20 life question in this case.
I'm going to have to look into it more because there is a possibility also that these charges could be upgraded based on the defendants, the victim's injuries and so forth. We've got some, it looks like some pending FDLE and everything to do with some recovered evidence when he went into surgery.
Judge, there's a great deal more to the fact situation than what was just described for the court, and a lot of that is in dispute. I would point out that my client just turned 19 years old. He's very young. He has no record.
Happy birthday.
He has obviously the ability to maintain private counsel, and he does have the ability to make a reasonable bond. He would be living at home with his family and returning to court as necessary. We're going to see this through and make sure that he's represented throughout this. He's better served being at home and working and with his family. Had he had a prior record or failures to appear, I could understand the state's position, but $250,000 is tantamount to no bond at all, Judge.
Mind if I ask your client one question? You're
Yes, sir.
welcome to object if you choose to do so.
Yes, sir.
Sir, where is your community in Alabama? What part of the state?
Talladega County.
In Talladega, that area? Okay.
Is a bad part,
This
Judge?
time motion granted, set bond the amount of 100,000 cash professional. Condition is that you'll be in Bay County only to make court appearances, which hopefully we can set in the afternoon to accommodate travel on the same day.
Yes, sir.
And, but otherwise, obviously you'll not possess any weapons or firearms of any kind. You'll have no victim contact whatsoever.
Yes, sir.
You understand that?
He asked for 50, ended up with
Thank you, Judge.
100.
Do we have another court date for him as well?
I mean, it dropped $150,000. So I guess that's a
I don't
win.
think anything will occur between now and then.
Oh, no, yeah.
Still looking for some discovery, so
I mean, do you guys have somebody
I'll
else
be
go
talking
to
for
get
next
2
Thursday,
grand
is that right?
from?
And we're just saying that we should probably move it because nothing's an October date.
I think an October date makes sense, and that will give him time to go ahead and make financial arrangements and get his bond squared away. Yes, ma'am. Yes, ma'am.
All right, so ordered, and we'll cancel the date for next Thursday.
Anytime, Dave.
Thank you, Judge. I
Anytime.
believe that concludes my business. Maybe.
Thank you, sir.
I mean, they still got to come up with 10 grand to get them out.
Good morning, Judge.
Good morning.
Your Honor, Chris Scott here on behalf of Rebecca Clark. She's got 4 case numbers, 21-1269, 21-3496, 21-3722, and 22-2448. Your Honor, we're here today on Ms. Clark's motion to reinstate bond or to release her on her own recognizance. Your Honor, what we have here is we had a trial management set that Ms. Clark failed to show. That was on May 20th of this year. Your Honor, unbeknownst to me at that hearing, Ms. Clark was receiving medical attention
And
and
present any testimony today.
from Ms. Clark, Your Honor.
If you raise your right hand to be sworn, you swear affirm testimony you give will be the truth, whole truth, and nothing but the truth, so help you God.
Yes, sir.
That is good to see you.
All right, can you state
Yeah.
the full name for the court, please?
Rebecca Sue Clark.
And May 20th of this year, you had a trial management that you failed to appear. Is that right?
Yes, sir.
Why did you fail to appear at that trial management?
I had spinal surgery, sir. They had to remove L4, L5 out of my back. And I had just got released from the hospital and I was in severe pain. There was a situation where they messed up my medication.
What was the date of your
And-
surgery?
The date of my surgery was April 28th. And I was just lost my grandma. I lost my house at that time. I know we live with my mom. I was
She
going
lost
through a
part of
lot.
her
I
back?
walked into a probation office. I'm not on probation. Asked them to call the police for me because at the time I just felt suicidal. I said I need some help. So the police picked me up
Were you Baker acted?
and they took me to Bay Behavioral.
Okay.
I thought I was going to be under a Baker Act and I sat there for several hours. And they said, ma'am, you're in a lot of pain. I said, yeah. And they said, well, you just had back surgery. We don't think you're suicidal. We think you just in severe pain. They called an ambulance. They took me back to Gulf Coast. I had
Wow,
water
that's
on my
good.
spine from the surgery. And that's what happened. I was in the hospital and under like a Baker Act at the time.
And is there any recovery or physical therapy or anything following that surgery?
I was supposed to go into 10 weeks of rehabilitation. I've had absolutely none. There was no open beds at the time. And I got arrested and been in jail. I've not even had followed up with my surgeon or anything. Like from severe back surgery, I've been in jail the whole time.
So if you were released from incarceration, is there currently medical attention, rehab, or?
That's what I figured.
The jail was going to take me to the surgeon and I said, being in stripes, that would be an embarrassment to me. So they set me an appointment for Monday, hoping that I got out today.
Okay, and Ms. Clark, are you from Bay County?
Yes, sir. My whole life, 46 years.
Other than failing to appear at that trial
She got
management,
that
did you
water.
consistently show up to court?
Yes,
On
sir.
her
Do you have
spine.
any other incidences where you failed to appear?
No, sir.
Um,
Can
if
you get
were
water anywhere?
released, Where would you be living?
Colorado Street with my mother,
Okay.
4717.
Other than your mother, do you have any family, any
My
other?
whole family, 4 grown children, grandchildren, brothers, sister-in-law, aunts, uncles,
Okay, and so,
and they live next door. My brother and sister-in-law, and one of my kids right next door. One of my grown daughter is 30, lives at the other end of Colorado Street.
I've heard of
and
water
if
on the knee.
If the court doesn't release you on your own recognizance and instead sets a bond, because you're currently held without bond, right?
I paid several bonds, but I'm disabled on disability. I've been in jail since May 31st, so I didn't receive June, July, or August disability check. I have no way of paying a bond. I'm
Oh,
disabled.
they
I only
won't
get
pay you while
840
you're
a
in
month.
jail? I didn't know that.
Okay, so if
Carol,
the court
Carol.
doesn't release you on your own recognizance, you don't have the ability to pay. Okay.
Thank you for the 10.
So if you are released, could you then receive those disability checks?
I'm not really sure how that works, if we're allowed to receive them being incarcerated. I'm not sure how that works with this SSI.
Do they pay
I'm
criminals?
gonna ask for them, but I think if you're in a hospital or jail 30 straight days, I'm not really sure how that works, sir.
Okay.
I'm not trying to get in trouble for fraud.
I have no further questions.
Do you have any? I'm sorry, go ahead.
I'm sorry, Your Honor.
Can't get it.
With all candor to the court, the most recent charge, 22-2448, that's an uttering of forged bill. The alleged criminal violation, according to the information, was in April 28th of 2022. So I just wanted to point out that she did pick up a new charge, but it was prior to missing that trial management. And I have no further
If
questions.
it changes,
You don't have to
it
respond to
will
that.
not have
I
the
was
word
just letting the court know.
show on the end.
Questions
This
for
is
the
not a
defendant in
show.
argument?
All right. Let me,
Thank you, Shanta.
no, go ahead.
And so, Your Honor, in addition to the defendant's motion to reduce or reinstate the bond, the state also has a motion to revoke bond that is pending due to the fact that she did pick up new charges. And just for a history, I don't know if you have the state's motion to revoke bond in front of you, but just so that the court's aware, in 21 CF 1269, this defendant was arrested in March of 21, charged with aggravated assault with a deadly weapon for an incident that happened in March of 2021, and she was released 3 days later on bond. In 21 CF 3496, the defendant was arrested August 29th of 2021, approximately 5 months later, and charged with felony battery for an incident that happened earlier on that day, and she was released 4 days later out on bond. In 21 CF 3722, the defendant was arrested September 17th, 2021, not even a month after that second arrest, charged with grand theft, fraudulent use of a credit card for an offense that occurred in May of 2021, and was again allowed to bond back out on all 3 cases on October 4th of 2021. She was instructed at all bonds to not commit new law violations. She then again committed a new offense in April of 2022, for which she was arrested in June of 2022.
What?
And that has caused her bonds to be revoked, or she's being held on those. And at this point, the state would object to her bonds being reinstated because she has now had 3 bites of the apple to stay out in the community and continues to violate this court's orders to have no new law.
She just said she has had 3 bites of the apple to be able to stay back out in the community. Now, I'm going to say this lady has back problems. I'm sorry to hear that. That's terrible. Not worse than back pains. But for God's sakes, it has not slowed her crime spree down one bit, not even a little bit. So, water on the back.
Law violations while being allowed to be out on bond, and she is not able to comply with that. So we do not believe it's appropriate that she get a bond in these cases and that her bonds be revoked.
Could you clarify for me the date of the most recent charge?
She was arrested on June 8th of 2022.
I checked the information this morning, and the alleged violation was April 28th of 2022.
Yeah, exactly. Thank you.
April 28th, yes, sir.
Curious, and I thought I heard her say that was the date of her surgery.
Oh,
I believe it was before her surgery. Her surgery, I believe, she was saying was in May, and that was the reason that she failed to appear or
Well,
something.
the court date was in May.
Okay.
Said she had surgery in April.
She did say that, Your Honor.
Yeah. Motion denied.
And Your Honor, as to the state's motion to revoke bond in all those cases,
Granted.
thank you.
I believe we'll need a new court date.
How am I going to get this water off my back? I'm glad that they noticed the date as well as we did, it being the day she was supposedly had surgery. But she committed the crime right before. She just said, "Oh my God."
Next pretrial will be fine.
How you like them apples?
That works for me. September.
Do you think we'll have it resolved?
I mean, I've been in jail 80-something days, no medical attention. I have power of attorney of this man.
I've worked
for
with the
a
state.
cycle.
We're trying to get an offer.
September 29th.
Okay.
Thank you.
I had any
We'll ask
medical,
the jail if they can to transport her to that scheduled
Trying to lose
medical
it.
appointment on Monday.
I need
That's
medical
permissible.
attention bad. Can we disregard this? Oh, sorry. Oh, okay.
Hold on, I gotta go back to jail. I need to see a doctor. What are we doing here?
You guys case ready? Yep. Another inmate present or not?
I hate that this judge is a fill-in judge because I really enjoy.
Someone at the jail still in custody?
Well, yes, sir. We have Cotton, Dawson, and Faulkner.
Bring me Cotton. Cotton Hill.
Let's call
Good to
up
see
case
Mary
Hill and get
Lou
Cotton
Lou
into the
Gerald.
video room.
Yes, sir.
Where's Jeanette? I haven't seen Jeanette in the
We
last
have a
day.
case- another case
Jeanette,
ready
are
while
you-
they're getting
are
Mr.
you
Cotton.
kicking?
This is actually on the afternoon docket, but he was brought out.
Well, that hair. Nice hair. No, honey, I'm talking about him, not you.
Was on the-
Water on the spine.
Yeah, this is John Gilbert in cases 21-4620 and 22-0049. He's withdrawing his previous entered plea of not guilty and plea of no contest to 2 third-degree felonies in case 2249 and 1 third-degree felony in case 21-4620. Each of those carries a maximum of 5 years in prison, $5,000 fine or both. The agreement we've reached with the state is that Mr. Gilbert will be adjudicated guilty. He'd be sentenced to 22 months, Department of Corrections, concurrent on all counts and cases. There'd be civil judgment for court costs and fines of $1,078 in the drug case, $518 in the property case. Restitution would be in the amount of $994.46. Donald Crowley, that would be joint and several with Dylan
Mr.
Blackwell. For
Crowley.
$75 cost of investigation to Panama City Police Department. All those are civil judgment. He has 179 days credit against each of these sentences. He understands the Department of Highway Safety and Motor Vehicles may apply additional penalties. He'd submit to a DNA sample if required, and he'd forfeit any seized items. We stipulate to the facts contained the information is filed under oath, waiver reading of any discretionary costs. We're unaware of any DNA if tested would assist the defense.
I'm wondering if this lady
Mr.
that was
Right,
on
to
the
be
call
sworn.
monitor is a
I
witness.
swear firm testimony you give will be the truth, whole truth, and nothing but the truth, so help you God.
Yes, sir.
State your name, sir.
John Gilbert.
And Mr. Gilbert, you heard your attorney announce the plea offer. Is that your understanding?
Yes, sir.
All right. Did you hear me explain the hearing rights to everyone this morning when we began?
Uh,
The trial, your trial rights?
yes, sir.
All right. And you, is this your signature on the plea agreement?
Yes, sir.
And you read all this before you signed it?
Yes, sir.
So do you have any questions about any of your trial rights?
No, sir.
You understand them all?
Yes, sir.
You understand you give them all up by entering this plea as to each count of each case?
Yes, sir.
Could
However,
be.
you keep the right, so you're giving up the right to trial, all trial rights, and the right to appeal guilt, but you keep the right to appeal fundamental issues or issues on sentencing errors. And have you had enough time to talk to your attorney about this decision?
Yes, sir.
Are you satisfied with the advice given?
Yes, sir.
And has anyone promised you anything other than what's been said here today to get you to plead?
No, sir.
Have you been threatened or made to plead when you don't want to?
No, sir.
Had any medicine, drugs, or alcohol in the last 24 hours?
No, sir.
Or been committed to a mental health facility?
Yes, sir.
Tell me about this burglary and grand theft of $750 or more.
To explain it to you.
Yes, sir.
Yes. Let's hear it.
I was with Dylan Blackwell before up to the property. He loaded some things up. I was there. I didn't try to stop him. So I guess in part I am guilty of that.
Did you know he was burglarizing the place?
No, sir. I didn't know the property was even, it was supposed to be someone named Ashley's place. There wasn't even a house on the property. It was like I don't know what you call lean-to or something. The stuff that was taken, I didn't know what was taken. I didn't really feel like I should have to pay the restitution, but in order to get this resolved and get home to my children, I'm ready to get this over with.
Did you help him in any way go onto the property or help him move any of the stuff?
No, we drove to the property, picked me up, drove to the property. That was that. As far as what was taken, I mean, I thought it was all his until I got a warrant out for my arrest. I didn't know anything was being burglarized, none of that.
Well,
So
here's the point. If you were there merely present and not actively participating or helping him in any way, and you didn't know he was burglarizing it, you didn't know he was stealing anything, you thought it was his property, those could be complete defenses to these charges. You understand that?
yeah, I just want to get this over with.
If we get to the second case, that'll explain this.
So, no problem. The point is that you have to make that decision, sir. You're the only one who can
Yes,
make
sir.
that choice, because you do have the right to a trial. You have the right to present your defenses and let the issues fall where they may.
Yes, sir.
And that, and the state has a very high burden of proof in a case like this. And you could testify, explain what happened, and they could ask you if you've got any prior convictions, but beyond that, they couldn't ask you anything else.
It seems like,
without
there's
leaving
more to the
court,
story.
And that's rarely granted.
I
Yes, sir.
appreciate the
At any
judge's
rate,
honesty.
and then you'd have the right to appeal, obviously, if you're found guilty and you thought that was a mistake. But you're giving that all up by entering this plea deal.
Yes, sir.
And what about the possession of controlled substance?
I'm guilty of that. So, I mean, I don't, dealing with that and dealing with this,
Well, please answer my question. What did you have?
fentanyl.
Okay. How did you get stopped?
We was pulled over,
Why did they pull you over?
traffic citation, something about, not using my gilding or something like that, or not.
Were you
turning
the
signal or something.
driver?
Was I the driver? Yes, sir.
And had you failed to yield?
Yes, sir. I was putting on my seatbelt, and when I went to get over, I didn't put on no blink or anything, so.
Doing a couple things at the same time can be
Yes, sir.
distracting. So the point is, what are you doing messing around with that stuff?
Mhm.
It was in the driver's side of the door. It wasn't my vehicle, but I
Did you
get,
know it was there?
It was, yes.
yes, sir, I knew it was there.
Did you ever exercise any control over it?
No, sir.
Well, you may have a defense in that case as well, that while it was there, and while you may have known it was there, you never actually exercised any control over it. It wasn't yours. Although proximity would be taken into account by a trier of fact, they might find you guilty and reject your explanation. But you can testify about it and let them decide. So you may have a possible defense on that too. You understand all that?
Yes, sir. Just,
And you want to give up all of your defenses on both these cases?
yes, sir.
You think that's best?
Yes, sir.
And your plea to be freely, voluntarily, knowingly, and intelligently made. There's a sufficient factual basis to support your plea. Any possible defenses are voluntarily waived. And I have a score sheet with 56.7 total sentence points. Any objection?
No objection.
56.
All right, sir.
Would go to
This
solo
time you'll
training
be
like
adjudicated guilty on each count of each case. You'll be sentenced to 22 months in state prison on each count concurrent with credit for time served. You'll be required to pay $518. What was that for again?
The drug case has an extra $50, so that's $1,078. $518 is for the second enumerated case.
All right. Plus
Vacation
the
Creed, hello.
1,078,
Hello.
roughly 2,500 plus 2,700.
I had to come on since Coolio was there.
About
Celebrity
1,600.
appearance.
I mean, it doesn't
Well,
happen all the time.
I'm not sure on that.
Yeah.
Madam Clerk, what's your position on that? Is it only 518 on the? Okay. At any rate, so that'd be roughly $1,600, a little less than. And you have the right to a hearing regarding reasonable attorney's fees, since those are included. Do you need a hearing about that?
Tried to talk him out of this
Yes, sir.
plea the entire time.
And these are two separate cases, so there'd be two application fees, is that correct? Or was the?
Oh, did I miss a masterpiece?
Just once.
Oh, yeah.
It's taken into account on,
Gorgeous.
I think, the higher case or higher court cost sheet.
All right, and by agreement, Court costs, or excuse me, restitution is established the amount of $994.46 to Donald Crowley. And
Mr. Crowley.
there's a $75 PCPD cost of investigation. That's Panama City Police Department. All right. And any financial obligations are reduced to lien. You'll get credit for 179 days time served as of today's date. Any highway safety or motor vehicles may impose additional penalties, including driver's license revocation. You'll be required to provide a DNA sample and any items that were seized from you.
Yeah,
or
that
forfeited.
DNA sample is a killer nowadays.
You're
Boy, they
advised of
catch
your right to appeal
everybody.
within 30 days. You have the right to an attorney. If you cannot afford one will be appointed. Have I neglected to say anything or mention anything else?
No, Your Honor.
All right, thank you.
Somebody get that judge some water, would you?
I mean, he's 1 foot
And
in
we
the
have a
grave.
gentleman in
but they got
custody.
him
Your name,
saved.
sir?
For real.
The jail?
Cotton.
Mr. Gotten?
There's about one
Your Honor,
name.
This is Herschel Cotton. I had filed a motion to dismiss in this case, but the state has already filed a traverse. So
Matters moot.
yes, it is.
All right.
Move.
So, sir, do you understand what that means?
Fentanyl kill you.
No, ma'am. No, sir.
Your attorney can explain it all to you. The state has filed an objection and contradicted what has been said in the motion.
Wrench.
It was a C4 motion, as I understand it.
Yes, sir.
On undisputed facts, and the
means it's
state says there
explosive.
are disputed facts. So then it becomes an issue for resolve. It can't be resolved by this motion.
Thank you, Dave.
Thank you, sir.
Thanks, Dave.
How do we want to schedule?
Um,
Are you ready?
yes, we want to keep him on there.
Keep the trial date.
Yes, please.
May I ask for a continuance?
Your attorney can talk to you about that and make a choice there. Right now, we'll leave it scheduled for
On
trial.
your honor, the
I
state
sent
for
the
the week-
email.
Well,
Oh,
for the week of
Spicy.
September 6th, I believe that our trial week may already be full because we have a homicide case and a sexual battery case that particular week. So if the defendant is asking for a continuance in this case, the state would not object on that case.
That would be fine. I didn't realize that he wanted to continue it.
All right. So you,
I can't believe that.
I would
I'm
ask
sorry
that
to
we
hear
put it
that,
on a
Jay.
pretrial docket.
Creed, they're messing up the cocaine for everybody
Yes.
now.
Fine.
Fentanyl.
Cocaine.
sure, your attorney will be in touch. So you're getting the continuance.
Thank you, Your Honor.
You understand?
Yes, sir.
Thank you, sir.
well, they got fired up when he asked about that, didn't they? Yeah, they threw him a curveball,
We
apparently.
have, who's the next person who's in custody, ready to come out? Out at the jail?
We had a guy a while ago. $250,000 bond.
We'll call up another
Probably
case
down
while we're
for
getting Mr.
100
Dawson
grand
present.
for him.
Seems
Yes,
like a
sir.
nice
He's here
discount.
right now.
That's the
Oh, he
deep
is? All right,
discount.
we're ready on
Yeah,
Dawson?
he's right.
Oh, she's right there. The blonde.
It works sometimes.
She's standing up right now. That's her. So Creed, let me pause this real fast. You weren't here when we had this court on Wednesday.
Mhm.
The judge, a very lengthy case. I'm not really going to get into the case, but at the end of it, he said, okay, you go, I need you to go to jail. This is your sentence, blah, blah, blah. And the lady's like, can I change this and come back? I got some things I need to take care of first, please.
Mhm.
And he's like, well, and then the prosecutor's like, you can't do that, judge. You're not allowed to do that. This, and that. She cited all this stuff.
Oh, wow.
And so judge is like, okay, well, I'm going to vacate my judgment and have you come back next Thursday for sentencing.
Holy
So
crap.
he
Okay.
showed her, and he's a fill-in judge, and she reminded him that he was a fill-in judge.
Oh, wow. That's ballsy.
So it's been a love-hate between this judge and this prosecutor.
Oh, that's crazy.
All right, what are we doing with Mr. Dawson's case?
Mr. Dawson is pro se. He previously had the Office of Regional Conflict, and I believe that Mr. Dawson has filed a motion basically asking for the CPT records of the child victim
Hey,
that
Bigfoot.
provided testimony in this case that led to the charges against him.
He's on drugs here,
Previously, the state had provided the CPT records of the child for this case, correct, to your office? I believe
Along.
that since he's now pro se,
I
don't
like
y'all
to think so.
remember? Okay.
All right. So, Mr. Dawson, the state will be forwarding the documentation they've been given on that issue to you.
The defense, his prior
I'm
defense.
sorry, the
counsel, they
defense
already have it.
counsel, your former
Yes,
defense
we are
counsel.
in Florida.
Florida Friday, baby.
Get that to your client or your former client. How long do you need?
Uh-oh. Uh-oh.
Oh, he needs something.
We're having. Okay, sir, your attorney will send that to you on Monday. All right.
Hello,
Excuse me, Your Honor.
Go ahead.
Today was supposed to be my adversary preliminary hearing today, and my mother has the transcript in court today. So today we're supposed to be doing my hearing for adversary preliminary hearing. Slick ass lady.
That mic is very sensitive.
If I may pass them up.
Have you shown them to the state?
Let me show them.
I like
And the
that.
only motion I believe I've gotten from the defendant pro se is this motion for CPT.
Is there a previous motion filed by counsel that was scheduled for today?
I don't believe that Ms. McCarthy had ever filed a motion for adversarial probable cause.
No,
I
no.
will say that the defendant needs to be cautioned that those CPT reports are not to be
See it,
released to
Andy
anyone
Man,
outside of his
Man,
attorney or
man.
himself. So the parties are the only ones that are allowed to have those.
Your Honor, I pronounced the
Oh, hi,
adversary
Brenda.
preliminary hearing, my last court date, June 28th, and the judge set it for today, which is my right. I know I have to file a motion in order to do so. I did it in open court.
Did you file a written motion, sir?
No, sir.
Some of these people come
Does the
through.
clerk's notes reflect that was raised at that
It
hearing?
seems like they could be attorneys. They know so much about court.
It's all right.
So they're basically treating him, since he's a
I'm
fill-in
sorry, I
judge,
can't
kind
hear
of
you.
like when you're in school and the substitute teacher was there and you're like, no, you don't know shit.
Exactly. His ass put
All
her
right. And so under the circumstances, does the state recall anything about an adversary preliminary hearing or a defense counsel? Were you still counsel on the case at that time then?
Please step to the
All
mic.
right. And what's the purpose of handing me this? This looks like a child investigative summary with DCF. So this may be the report that we were talking about.
Yes, sir. That's the report that I've been asking for.
Sir, okay, hang on just a moment.
Yes, sir.
I mean, he raised his hand. I
And
mean,
this is what you need
He
to
did.
get to your client, or former client? All right.
That's from his mother. But I might have more than that, and I will.
How did she get
Child
a copy
protection
of it?
team.
I'm not aware of how she got a copy.
Okay. Well, at any rate, sir, apparently this DCF report has been provided, and your attorney indicates I'm going to return it to her and ask her to forward it to you. And you've been cautioned about not releasing that to any others. That's a confidential record, sir. Do you understand that?
Yes, sir.
All right. So getting back to the issue of preliminary hearing, how long has this gentleman been in custody?
Well, we're waiting.
well,
Is this a 40-day rule?
I didn't hear, I'm sorry.
I asked about how long he'd been in custody.
He was looks like he was arrested in November of 2021. I don't know if I can't go access the benchmark right now.
We got some,
He bonded out and it was revoked. I don't know.
got some attitudes in this court,
Let's
huh?
presume that he
Oh.
made the motion for an
Plenty.
adversary preliminary hearing. Is he eligible for one under these circumstances?
I would have to check into all of that, Your Honor.
Well, you filed an information. When was that
The
filed?
information was filed November 19th, so not long after. Well, the information was filed November 19th of 2021, which shows is the same day as his arrest on the court docket, but I can't pull up benchmark.
She's lying.
All right.
She's
They're
lying.
under the
Yeah, did you hear it?
circumstances, got a number of drug charges, as I understand it.
She lied.
And if the state filed an information Counsel, what's the state's view on the viability or applicability of an adversary preliminary hearing under these circumstances?
Dave.
His mumblings are the best. Shit, man.
And I'm sorry, just to clear up the record, Your Honor, it looks like there was the original information was filed March 26th of 2021 after his arrest.
There we
After
go.
his arrest.
Shillings, I get
After
that.
his arrest in February
I get
of
that feeling.
2021. And then there was an amended information filed in November of 2021. So that's where the corrected dates are.
He's been in since November.
So do you think they were filed within 40 days of his original arrest? The original information?
It certainly would have been filed before he asked for a probable cause, but it looks like.
Okay, well, it should have been, but was
within
it?
40 days. Did you hear the 40 days? I'm trying to look and see.
They botched this one.
I still don't see his arrest date, Your Honor, because I'm still not able to get access to it. But the offense
I mean,
occurred on February 18th of 2021. So if he was arrested on that date, and then his information was filed March 26th of 2021, that's 36 days. Thank you.
Good for the judge to ask those questions, though. She's like no information in front of
Great.
her.
He is great.
So that
So
would
that's
be
the
right.
date I just used for that computation.
Sir, under the circumstances of these allegations of your arrest and the fact that the original information was filed, although it's been amended, add subsequent charges, it's the original information it controls regarding adversary preliminary hearing. Under the circumstances, your oral motion for an adversary preliminary hearing is dismissed as being moot.
Excuse me, Your Honor.
Yes, sir.
The Florida Rules of Criminal Procedure 3.134, Your Honor, states that
Oh, here
if
we
I've
go.
been in custody for over 21 days and that the charges haven't been filed, I'm entitled to this hearing as a right, Your Honor. And it was well over 21 days that the state did not file charges, so I'm entitled to this hearing whether or not they filed after the 21 days, Your Honor, according to Florida Rules of Criminal Procedure.
Ooh.
And it looks
Sounds
like
like
he
it
filed
knows.
his original request for an adversarial probable cause hearing pro se back in April, and it was denied because he was represented at that time, and counsel did not pick up that motion after that.
No, he's arguably trying to renew it since he's pro se.
But then I would ask for him to file something since the state was not aware of that being heard today.
Well, so was it denied at that time by the
Yes, it
court
was.
on the merits?
It was denied because he was represented and he filed it as pro se, is that right?
Well, you can't do that.
All right.
One or the other.
Nightbot.
So he adopted.
Get off my lawn,
It was
Nightbot.
filed by counsel, is that correct?
No, sir, it was filed by the defendant and he was represented. So he filed it as a pro se filing, but he was represented at that time. So therefore he couldn't file his own motion because he was represented.
Yeah, he's under the circumstances. Well, I'm going to allow him to readopt it and you can schedule this matter for a hearing then. And it'll be up to the court to decide that. Set aside my ruling regarding the dismissal and the court can resolve it on its merits. That should be available. Why don't we go ahead and reset that for next?
They don't like this
Thursday?
judge because he's
I'll
too
be back on
fair.
that date.
He is very
Your Honor, that won't give me enough time to get subpoenas out for everyone. We need to have enough time. So we need to set it on a regular motion day.
All right.
Boy, I really hope that she has some stiff drinks tonight and gets to unwind.
Oh, no. She's like this every time we've come by.
Oh, my God.
It was worse the other day.
All right.
I mean, she is
Time frame, or
her ass.
scheduling, please.
You imagine her working
How
with
much time do you
marble?
need to get witnesses in? About 2 to 3 weeks?
Yes, sir. I mean, if we're setting it for 9/23, then that'll give us the time to get the subpoenas out.
All
It's our
right.
regular motion day.
All right. So, sir, it'll be set on September 23 with the witnesses available, ready to proceed.
And if
Yes,
he,
sir.
And I'm allowing you to readopt the original pro se motion that you filed back in, apparently in April.
and if there's,
Yes, sir.
if there's
Thank you.
someone he's wanting to have there, that's on him to get them there.
Say it one more time.
If he's got anything that he wants done for that hearing, that's on him. He's pro
Right.
se, so he's.
You're
gotta
pro
do
se,
that.
so you have to represent yourself there, sir. I
Yes,
do
sir.
want to remind you, that you're entitled to an attorney. If you cannot afford one, one will be appointed. All right,
Okay, sir. Yes, sir.
thank you.
Would that DCF paper be forwarded to me before the hearing, sir?
Your attorney said she'll get that to you Monday.
All
Her
right,
former
thank
attorney,
you.
I should say. She's got a copy of it. She's going to forward it to you.
I was gonna say, what,
right,
the guy
thank
still has an attorney
Your attorney
after all
said
that?
she's-
He doesn't have one. That's very,
Thank you, sir.
This guy
All right,
knew his
next
stuff.
case.
I mean, he may be a complete criminal, but
Yeah, no, he
he
sounded
was
like he knew it.
well prepared. He
Wait,
knew
that
quoting
was set for
statutes
1:30
and
this
everything.
afternoon, so if you want that one taken early, then I've got to let Mr. Overstreet know to come over. I didn't see him on the morning. We looked at it this morning, sorry.
All right, sorry to
If
disrupt
he
your
can walk
court. I
over,
wanted
I'll
to
give him
test
a
this
look.
out and see,
I
because
don't
we
have
want
it
to
on the
do,
morning docket.
at the very least, members only on the move today, so.
Yeah, be a very special members only. If it goes as planned, it can be spectacular. So there's still time
Yeah.
to join and become a member if you're not one like Dallas Alice is. You can do that, and we're going to see some. I think we're going to the fair today.
I think we are going to the county fair for members only. And I'm on the new phone, so that's why I had to test everything. Anyways, enjoy court. I'm going back to the yard sale.
Oh, good luck.
And yeah, I'll make sure when I leave not to hit end this time.
Please, and thank you.
Have fun. Bye.
Thanks, Creed. Bye. Creed, everybody. Creed. Making a special appearance. That was
Well,
nice.
I'll ask him real quick. If he just wants it. I know he's planning for it to go to trial. You got it? Okay.
This lady.
Sorry.
Who's the gentleman there at the jail now?
Name.
Philip Faulkner.
Philip
Mr.
Balkner.
Faulkner?
Morning,
sir.
Your Honor. I'm
Slow
here on
mo-
behalf of Mr. Faulkner.
slow
We're hearing
motion.
cases 22, 2231, and 204609, which is the VOP. He was just arraigned on Monday. We placed him on today's docket with the hopes of reaching resolution. Unfortunately, we're not able to reach a resolution today, so I would request that we place him on the next pretrial.
So ordered.
Philip, I'll be out to come talk to you soon, man. All right, thank you. September pretrial. Please.
Good for you, Fred Franklin.
All right, thank you.
Thank you.
Lucky you.
You have anyone else at the jail?
No, sir, that's it.
Thank you so much. All right, Council.
Thank you.
What was her name? Kathy? Is that what he said? Had me all excited, Fred. That yard was for sale if I wanted to buy it from Creed. Up for grabs. And bring we got plenty of people in the courtroom that would appear. Oh, wow. She's a piece of work, I'm telling you.
Your Honor, Alan Drivers before you in case 220301. We were here for a motion for bond reduction to pretrial release. However, there have been continuing negotiations. So I'd ask that this be moved with the state's
This guy's a Fortune
agreement
500
to next Thursday,
business.
either for a resolution or a brief bond hearing.
Any objection? Mr. Driver, to you? All right, so ordered.
Well, it seems like we're doing a lot of motioning over here. So
Okay.
we're going to jump over to licking.
Mr. Wigfall?
Going to Licking. Who wants to join me? Going to Licking. Licking County, Ohio, everybody. One of our favorite places to go recently. I mean, we spent a lot of time there. A lot of time, but it's well worth it. One of our favorite judges is the ladies around here love this judge. He's a hottie. He's a bit naughty. It's Judge George, everybody. Judge George. Oh, come on, Judge George. Do your thing, baby. Do your thing. And why is there no volume, Judge George?
I drive a blue Kia.
Okay.
The police officer read my tags and then he pulled me over. So then we started talking and he was like, do you have an warrant in Newark? I said, I've never even been to Newark. I don't know where Newark is at.
Okay.
So then he was like, well, you're gonna have to go up there. I'm not gonna arrest you, but going up there and get this cleared up. So that's why I'm here. So I had no clue about this.
Good news. I love Godzilla.
I moved out because the address that's on the docket is 861 Brittenell Avenue.
Okay, I don't know that I have an address, but there's no address on the complaint.
I moved out of that address back in 2016.
Okay.
I've
That's
been in
Columbus.
my current address for 7 years.
Okay. All right, let's see here. I want to see what the
As literate.
police force says.
And somebody else moved in that house after I moved in.
And they
Moved
put
out.
the
They
truck
moved
there.
in when I moved out, rather.
Only a couple of people in court today.
Okay. Did you live in Steubenville?
No,
Okay.
no.
Okay. Well, if what you're saying is true, they got,
All my life.
sounds like they got the wrong Tiffany wire.
Now, I do have documentations here from the Franklin County where I'm paying a tax bill from 2019 at the current address where I live
Okay.
at now.
Okay, I assume you want to plead not guilty then?
Yes.
Yeah, okay. All right.
Shake that one off.
Okay, if you can't afford an attorney, file that applications today. Otherwise, I'd encourage you to hire an attorney.
Okay.
You better be
Any
careful.
other questions today?
No.
Okay.
Questionable
Make
stuff,
sure
man.
the clerk has your correct mailing address, okay?
Okay.
All right, thank you. Next matter is 22 TRD 3365, State of Ohio versus Mame Duke. Joe?
Was you gonna try to get?
Who?
I'm gonna start with that one.
Yes, I have to, because
Is Jeff? Is that how you pronounce it?
Duke.
Duke.
You said it right last time I was here. You said it
Oh, man. Okay, all right. So you missed your trial date, Mr. Duke.
Yes, Judge.
He is
what
the
happened
dude.
there?
Yeah, what happened is, I had a original court date at the first place, and you guys canceled it and gave me a new court date.
Okay.
I was here at the wrong date. And then
Is he
they told me
is he
they
doing a
canceled the
Cajun
court
accent?
date, but since I am a truck driver, I was gone.
Okay.
So I just got back home yesterday, and I see I had a court date, on the 8th.
Dead on.
Okay. You want that reset for trial? What do you want to do?
Yes.
Okay. All right, you gotta make sure you're here, okay? Because
Sure.
what happens is we issue a warrant when you don't show up for your hearing.
I know.
Okay.
Do you know which day it's gonna be so I can?
I don't. It's not my case. It's Judge Stansbury's case, so his scheduler will set a new trial date. I don't know if they have a specific time where they do their speeding trials. The 8th was a Monday. That's a little odd.
Uh-oh.
Because that's his jury
Odd.
Monday, so I don't know.
Good to see Odd.
I don't know how it got set on the 8th, but yeah, I don't know. I can't tell you right now when it'll be. Okay. But you
It's kind of tough for me since I be done
Sure.
all the time,
I understand. Yep. And you might email the clerk or the judge's office to let them know, your availability here in the near future.
Okay.
Okay.
All right.
All right. Thank you.
Thank you.
As soon as we get
Next matter is 21 CRB 426 State of Ohio versus Jennifer Harper.
we'll jump over to Judge Herman Marbell. I wish F Pod was still around.
Ms. Harper, I have a complaint here charging you with child endangering. Did you receive a copy of that complaint?
No.
You did
Oh,
not?
that's a serious charge.
I don't have a mail return. Do you live in 353 Wayne Avenue, Columbus? Okay. All right. Do you need me to read that to you then? Okay. It states that the Heath Police Department, being duly sworn according to law, proposal says on or about the 21st day of March 2021 in the city of Heath, Licking County, Ohio. One Jennifer Harper did recklessly, being the parent, guardian, custodian, person having custody or control, or person in loco parentis of a child under 18 years of age, create a substantial risk to the health or safety of the child by violating a duty of care, protection, or support. Contrary to section 2919.22 of the revised code,
Guilty.
misdemeanor of the first degree, this crime is commonly known as child endangering. Any questions about that charge?
I mean, it's gotta be one, okay, yeah, that's fine.
It was Heath report of a child locked in an unattended car.
Oh my God, lady.
Let's see. Is there an address?
No, I know where it was.
Okay. All right.
Well, I know what it
Any
was.
questions?
I definitely
Any
did.
other questions?
At least the hound.
Irving with Drive. How would you like to plead today?
Not guilty.
Go on.
Okay, you posted bond, looks like today, is it today? Okay, yeah. So I'll continue your bond as posted.
Probably too young to be locked up in a car by
You have a
itself.
different address now? You put a different address on the bond sheet.
I was just
Lockport or Asheville, okay.
Yeah.
doing some shopping, Your Honor.
All right, thank you.
That $304 or whatever, how is that given back?
If you show up in the case and you finish the case,
The next
then the
one.
person, she can get her money back after
Do you
you,
know-
after you appear and take care of it.
Do you know how long it's gonna be? Because I'd like to get this taken care of.
I mean, it just depends on the prosecutor and if you have an attorney, talk to them, or did you fill out an did you fill out an application for an attorney? Are you gonna hire an attorney? No? Okay. So it'll be set, for trial pretty quickly.
F that lady into A. I don't want to hear anything about no kids. Ain't got no damn excuse for why locking your kids in the car while you going somewhere. Take your kid in with you. For God's sakes. Just take the kid in with you. Even if he cries a little bit. It's all right. Bitch.
This was out of my control. The reason that my law was struck in the first place was somebody relied on me. Just go to court and beat the trial. Or that's proving some retroactive allegations that made me go to jail in the first place. When somebody found you and makes you prove something, then that's out of my control. But I was making my payment up until when that happened.
Okay, but we're 11 years later. Or 10 years later, or actually more probably.
Like I said, within this month, we wouldn't be here if this thing hadn't happened. We wouldn't be talking about this. The truck would be mine. I would have been owned it and everything. So,
You in the car?
it was taken from me, was my fault. People still got their truck back. They sold it. They made their money. All my payments are up to date until the incident. That's all I can tell you.
What was the incident? Maybe I'm not understanding.
I went to jail. Somebody said it. You know what I mean? So I went
Did
to
it have
jail.
something to do with the car?
Excuse me?
Did your going to jail have anything to do with this truck or car, or whatever it was from RPM?
Yes.
It did.
I know Brent hates his job. He has to.
No. Were you charged with a crime that had something to do with?
No, it had nothing to do with the truck.
Well, what were you charged with? What were you convicted of?
Felony assault, felony possession, felony murder charge.
Well, how does RPM have anything to do with that?
Because when somebody makes allegations like that, don't you get arrested and you go to jail, then you sit in jail till you make your bond, and then after you make your bond, things happen that you can't control. I can't make payments when I'm sitting in jail, correct?
Yeah, you can't. No, that's true.
After I got out of jail, when you got out of jail, you go to court and you take care of it, right? Which I beat in trial. So then somebody lied on me. And by them lying on me, baby, get this position with RPM people. So that should clear me of everything. I've been cleared in court. And this should be cleared as well. If somebody lied on me to make me lose it, otherwise I wouldn't have lost the truck in the first place.
He lost his truck.
So you're in jail. And let's say you can't pay. No. Let's say you were in jail or somebody's in jail. And they can't pay their consumer's power bill. And they got food, they got lobsters and steaks and really expensive stuff in the freezer. The power goes off because they can't pay their consumer's bill because they're locked up in jail.
Yeah, quit making noises over there.
Is it our consumers because they lost the steaks and lobsters and expensive stuff in the freezer?
Depends on that situation. Some people if they have a wife or partner, they find that partner pick up the slack.
I'm not talking about that. Let's say there's no other factor other than person is in jail, can't pay the consumer's bill, power shut off, freezer with expensive meat on it
Uh-huh.
goes off, it's all lost. Is that consumer's fault?
No, but consumers will be paid once that person is cleared, because it wasn't, it's not consumer's fault, but somebody made that allegation to make you lose income and money to pay your bills, then you have to go clear it up in court. And once you get cleared in court, then that's when consumers, you might get cut off, but they'll understand what happened. And once you're cleared,
Full of
everything will be
stuff
fine.
here.
So, I don't understand.
You-
But if you're innocent,
Your Honor, it sounds to me like he has a claim against potentially some third party for lying that caused him to go to jail, but I don't, that's what I'm understanding. I don't think it has anything to do with our hearing today.
well, what I'm telling you, Mr. RPM, man, was attorney for them, is all my payments were up to date until that happened. I would own that truck for a fact if I hadn't went to jail. That's what I'm saying. And I went to jail.
How long were you, well, maybe I gotta ask the question. How long were you in jail?
I was in jail for 90 days till I found it out.
90 days?
90 days, that's right, 90 days, because I paid an attorney for money.
Oh, hey, I thought you were in jail for like a year or something.
No, 90 days.
3 months.
Yeah, a couple months. A lot of people was thinking.
So why didn't you contact RPM and say, I'll pay it when I get out?
Well, I couldn't get hold of RPM. If I didn't have people get, RPM knew where I was at. And something happened where the person.
I like to make my one phone call to the
If I went to jail, I didn't know what
finance company for my truck.
whatever, but I was deal that I was made, not honored, so I don't know what happened to the truck.
No, I mean, could you not have written a letter to them?
And I had people verbally call and tell them.
No, listen to me.
They called me back.
Listen to me. You couldn't have written a letter to them saying,
Fight.
you couldn't have,
Somebody else had spoken to them before me.
well, okay.
I was in jail.
So you could have, right? But you didn't.
You could have.
Now,
Would
I
have.
was
Should
trying
have.
to work on my case, getting out.
No, but you would have to agree that writing a letter to them, explaining your situation would have been a responsible thing to do. Would you disagree with that?
No, I wouldn't like to disagree with that.
I'm sorry, say that again. I didn't hear you.
I'm not gonna disagree with you with that.
Okay, so you agree with that, at least. That wouldn't have been unreasonable to expect you to do.
Yes.
Right.
Right.
Other things, what's going on, not thinking about that, especially when you thought it was already being taken care of.
Okay, but how is that RPM's fault? It's not.
Well, like I said, they got the truck back. They made the payments. Nobody said nothing to me about it. And the reason that we're in this situation.
But they sue you for they're allowed to sue you for, listen. Mr. Cradaville has heard me say many times, before COVID, before we were all having to wear a mask, I used to say to Mr. Cradaville, he's cringing now because he knows what I'm going to say. You know, he represents a company where they have on the commercials and on the billboards, somebody wearing a mask like a bank rob. So who would even want to go there when they got somebody who doesn't want to show who their identity is? He says it's a superhero or something. The point I'm making to you is, it's not their fault that you went to jail. And it's not their fault that you didn't let them know what was happening.
Well, like, it's not their fault that I went, but the reason I went is the reason I didn't get paid. So therefore, whose fault is that?
Yours?
No, I've been cleared. The court's clearing me. It wasn't my fault. So whose fault is that?
Somebody else.
I mean, listen, man.
Listen to me. Listen to me. I'll tell you why I'm saying it's yours. Yeah, I'm saying it's yours because the responsible thing to do in that situation Look, the responsible thing to do in that situation, if it's something that's really important to you, like a car or your house payment, let's say it was your mortgage. Not like you're renting an apartment or something, but a mortgage, something that you put money, significant investment in. They do let you write letters, and I would have written a letter. I think I would have tried to, or at least got somebody on my behalf to do it, because that way, one, you're doing the communication yourself. Two, there's a paper trail. I don't guess you get to make copies in jail, but you probably don't.
A lot of things you can't do in jail. You want to make it better, who knows?
Well, but what I'm saying is to blame them because you were locked up, or say that they have some kind of responsibility for that. I'm not there. I just don't see that.
I'm not saying that that's their responsibility. I didn't say that I got locked up. I'm saying the reason if I got locked up is the reason why I wasn't able to make the payments.
I understand.
When is he gonna make it?
Listen, I perfectly understand that. The thing is, though, people are unable to make payments on bills for lots of reasons.
Oh no!
Right? They lose their job.
Girl Scout cookies.
They get hurt. Get sick. Go to jail. There's a whole number of reasons why people sometimes are not able to pay their bills.
Yeah, Brent's packed up like a kid waiting for the school bell to ring in 3 minutes.
Unless it's explained to the creditor, what's going on.
Is he smelling fingers?
It's not necessary. It's not their fault. I mean, I
hear what you're saying. I know that it's none of the problems you're talking about, not paying my bills.
Listen, I think creditors need to be reasonable. If somebody is sick or lost their job, gone to jail, whatever the situation is, those kinds of things, you would hope that the people would be reasonable, especially if everything was up to date, like you said.
Yes, you would. So I mean, that's my whole argument.
But no. But you didn't let them know. At the end of the day, you didn't really let them know. That's the bottom line.
They knew, Your Honor. They knew I was gone. They knew.
How'd they know you were in jail?
They got the truck because the person who was with me when I got arrested, who was supposed to get the truck, had contact with them. I had visits. So if you want to go on my visit, verify my visit.
I'm not going to do anything like that.
But I had ordered people. I told them what to do while I was gone. I can't make people do stuff that, I'm in jail. So stuff I can do. But
Judge Herman is
they got the truck back out. So somebody knew what was going on. They got the truck immediately. So they knew I was gone. So
you got the truck back?
Yeah, they got the truck back. They got it back.
No. I thought you said you got it back. Okay, never mind.
Your Honor.
Okay.
Even if everything he says is true, it's not.
Yeah. Why are we still talking about it? He's letting go and go and go in usual Judge Herman fashion.
It wasn't my fault. If I hadn't went to jail, I would still have that truck today.
Well, then maybe you ought to sue the person who falsely accused you.
There you go.
Maybe they should be going after instead of me because I'm clear. So maybe they should go after the person that pressed on false charges.
They don't have a contract with that person. They have a contract with you.
Brent just wants it settled and done with.
Let me say it again. They have a contract with you, not that other person.
And like I said, another thing that the RPM is not a bank. They don't finance nothing. They didn't lose any money.
They are.
All that money, they didn't lose any money. They're not a bank. They didn't finance nobody nothing.
Yes, they did.
So how do I owe them money and give anybody?
I said no.
Okay, so is that the extent of your argument for why you should have another date?
All of that in one, yes. We can go into jail, falsely accused.
No. Why you should have another date for the one you missed. That's what we're here to talk about, really.
No,
Really?
yes, that's my favorite, to put it.
Well, are you just basically gonna tell me what you told me now?
If that's gonna be enough to get this thing consent in your eyes.
It's not. Right now, it's not. So far, I haven't heard anything.
No, I see the attorney will take care of this. That might be enough for you
Yeah,
guys.
those are good
Okay, all
courtroom
right. How long do you need? How long,
Really good.
how long do you need to get a lawyer?
Travis County.
Tell you what,
Your Honor, you previously
Tell you
gave him
what.
60 days to find an attorney, which apparently was not long enough.
well, he says he needs another 30 days, Mr. Cradaville.
He said a lot of things.
Let
you
me
know.
say this, let me say this, Mr. Burge. Listen. I'm listening to what you say. I've listened to really every word. I'm not following, I don't think I agree with your logic. But I'm gonna give you another 30 days to get a lawyer. But I want you to understand something.
I love
I'm not real good on the dog ate my homework. Or the cat swallowed the vacuum cleaner, so that's not why I was here in court. I'm not real good on, flimsy kinds of excuses. You know what I'm saying?
Yes, sir.
And you probably figured that out, right?
Yes.
Okay.
All right, so he's going to give
So
him
you
more
probably
time.
know.
We're going to jump over to Travis County Court with the magistrate court judge sitting there talking to people in jail. So let's move our way on down the line. By the way, if you haven't liked this video yet, what are you waiting for? Do us a favor, slap a like on it. It helps us stay in business. Small business.
A conviction of a criminal offense can affect your immigration status, your right to be in this country, and your ability to become a
Right on
naturalized
time.
citizen in the future. And lastly, if you're not from the United States, you do have the right to request that we contact the embassy of your home country and let them know that you're here. Is there anyone here who's not from the United States and you want us to contact your home embassy? No? All right. I know you all want to get out of jail. If you're able to get out of jail, you need to make sure you show up for all your court dates. If you don't, you'll be rearrested. It'll be a lot more difficult for you to get out of jail once you're back here. Now, there are 4 ways to get out of jail. The first way is to qualify for a personal bond. If you were to qualify for a personal bond, you'd be released for free based on your promise to come to all your court dates. You'd have a bond amount set, but you would not have to pay any of the bond amount to get out of jail. Now, personal bonds are offered in instances where the case is not too serious and where we have a reasonable certainty that you'll come to court when you're supposed to, and that you won't.
Also, while he's reading that, don't forget today is Florida Friday on We Gotta Chase. Some really good stuff that I promise you, I know you haven't never seen before, or at least not with me. So that's all that counts. Make sure you're there for 4:05 today, right here, wherever you're watching this, unless you're watching on We Got a Case, which is our case only channel. Subscribe to that. I'm sure one of the beautiful mods has dropped the link by now in the chat. So make sure you grab that. On with the show.
That in Travis County, most bail bondsmen tend to charge around 10% of the bond amount. So, for example, if your bond amount's $5,000, bail bondsmen often charge you around $500 or more as their fee to get you out. You can also hire a lawyer, an attorney, can come down here and try to convince me or one of the other judges to give you a personal bond that you weren't able to get on your own. And if you don't have the money to hire your own attorney, you can request a court-appointed lawyer, and they can do the same thing. The last way to get out is to pay the full amount of the bond in cash. If someone comes down here with the full amount of the bond, not 10%, but the full amount in cash, cashier's check, or money order, then you'll be released. And as long as you come to all your court dates at the end of your case, you'll get your money back. Whereas if you hire an attorney or a bail bondsman, whatever money you pay them, you generally won't get back. That's their fee to get you out. Those are your 4 ways to get out. Qualify for a personal bond, hire a bail bondsman, hire a lawyer, pay the full cash bond. Regardless of which way you use, make sure you come to all your court dates or you will be rearrested. I'm gonna call your names. I'm gonna tell you what you're charged with and your bond amounts. And then I'm gonna ask you whether you want a court-appointed attorney or whether you want to hire your own lawyer. If you have any questions, go ahead and ask me at that point, and I'll do my best to answer your questions, okay? Denise Watkins?
Yes, sir.
Miss Watkins, you're charged with a Class B misdemeanor criminal trespass. Your bond amount set at $100. However, I'm gonna approve a personal bond for your release, so you're gonna get out of jail today for free based on your promise to come to your court dates. You have one condition. Besides coming to court, you are not allowed to go on the property of the Sunrise Mini Mart at 907 East St. John. You understand that?
Stay away from the Sunrise Mini Mart.
Under no circumstances can you go on that property. Are we clear about that?
Yes, sir.
All right. Do you want a court-appointed attorney or do you want to hire your own lawyer?
Court appointed.
All right. You're going to be released in the next couple of hours. Make sure you show up for courts and stay away from that property. One other thing, Miss Watkins,
Yes,
you do have a warrant from 2 years ago for theft. Now, this is a ticket, so it's only punishable by a fine, and it's handled over at municipal court over on Burleson Road on the east side. Now, I'm not going to hold you in jail on that, but when you get out of jail today, you're going to have a piece of paper with the court date telling you when you need to show up for that. You don't need a lawyer for that, so you can if you want, but you need to show up for your court date on that as well. Do you understand that?
Okay, I have a ticket, sir.
It's a ticket for theft for shoplifting from back on November of 2020.
Okay, I wasn't aware of it, but okay.
So when you get out of jail, you're gonna have a paper telling you your court date on the criminal trespass charge downtown at the courthouse, but you're also gonna have a court date for the theft charge over at municipal court, which is on the east side on Burleson Road.
Okay, I have a question, sir.
Go ahead.
At the time that the incident happened with the criminal trespass, I was explaining to the officer, they sell chicken at the store. And,
I don't want you to get, I don't mean to cut you off, but I can't talk to you about the facts of the case without your lawyer present. I know you have your side of the story, but I just can't. Whatever you say can be used against you. This is a recorded proceeding, and I don't want you to say anything that could potentially compromise your interest.
yeah. I mean, it's nothing major. I was just saying they served me in the store. You know, I was wondering, like, when you have a criminal trespass, you know, why would they serve me in the store?
Talk to your lawyer about that. The allegations in the affidavit have to do with you allegedly panhandling there. I don't want you to comment on that. I want you to talk to your lawyer about it, okay?
She says, well, selling chicken or buying chicken?
Judith Ramsey. Miss Ramsey, you're charged with a Class B misdemeanor driving while intoxicated. Your bond amount set at $2,000. However, I'm going to give you a personal bond as well. You're going to get out of jail today. Make sure you show up for all your court dates, okay?
Do I have to show up in person for the court dates?
Generally, now, once you hire a lawyer, your lawyer can show up for some of those court dates without you having to be there if they make necessary arrangements with the court. There are some courts that are still doing virtual hearings where you can show up virtually on by Zoom on the internet.
There we go.
But that's something that you'll have to discuss with the court to make sure that that's something that they will be willing to make available to you. Okay.
That's an El Caco, by the way.
So when you get out, you're gonna have a piece of paper telling you when your first court date is. It'll be in the next couple of weeks. That is not a virtual docket. You need to actually show up for that. When you go there, then you can inquire about whether there's going to be some options to do a virtual docket at some point. And like I said, once you hire an attorney to represent you, your attorney can make arrangements with the court to try to show up for some of those early court hearings without you actually having to be there if they make those arrangements with the court. Do you want a court-appointed attorney or do you want to hire your own lawyer?
No, I think right now, do I have to have a lawyer?
You do on a driving while intoxicated charge, yes.
I can get my own.
So you're gonna hire your own? Okay. Any questions?
How many court dates are there?
Well, it depends on how soon the case gets resolved. They
there
can
like
be quite a
age
few.
limit
I mean,
for
these
the
kind of cases
cell
can last
block?
a number of months. And then if you end up deciding you want to fight it and set it for trial, it can last longer. So that's something for you to talk to your attorney about. If you have a reason why you want to get it resolved as soon as possible, that's certainly something to bring up with your lawyer. He'll know what to do about that. Okay. All right. Good luck. Devani Castillo. Ms. Castillo, you're charged with a third-degree felony, possession of controlled substance with a bond amount of $3,000. You also have an out-of-county felony out of Hayes County. This is for a failure to appear on a felony possession of controlled substance charge. And the bond amount that has been set by the district court for this bond forfeiture is $100,000. And that's a cash or surety bond, meaning you can't get a personal bond. It has to be the full $100,000 in cash or a bail bondsman. Bail bondsman will often charge you 10%, which in this case will be around $10,000. The other way to get out, Ms. Castillo, is you can talk to your attorney. Your attorney can go talk to the district judge in Hayes County and try to convince them to lower the bond or reinstate the old bond. They can advocate and explain why you missed court and things like that. But that's something you'll need to discuss with your lawyer, okay?
All right.
Do you want a court-appointed attorney in both Hayes and Travis County?
No.
What's that?
Can it be a different lawyer, attorney for Hayes too?
That'll be up to the Hayes County Court. Well, I wouldn't have any control over it. You can request a court-appointed lawyer, and then when you get there, if it ends up not being the one you want, you can bring that up with the court.
I mean, I get it, I don't know.
What?
I don't know, I mean, I guess so.
Court-appointed? All right. All right. Do you have any questions?
It's not the table. That's her lunch tray.
No? All right. Make sure you show up for all your court dates. Good luck.
She's having a hard time.
All right, Judge, I'll go start pulling posts 1 and 2.
Sounds good. Thank you.
The last time I saw a pair of jugs that big, 2 hillbillies were blowing on them.
So we're going to go ahead and call it a day for over here on We Got a Case. I appreciate everybody coming by. It's been a lot of fun, some good times, some bad times, and Creed time. Everybody was here. It was a good time. If you didn't see today's show, shame on you. We're shaming you right now because you're not here. But here's the thing you need to remember. Like this video. Subscribe to our We Got a Case only channel. That way when we go live, you don't miss out. Because you never know when YouTube can turn its back on you. Just like Facebook turned its back on us. You know who didn't turn our back on? You guys. You didn't turn your back on us. Lobsters. Oh, we learned so much about lobsters today. If you have surf and turf in your fridge, you better not get locked up because it's going to go bad, real bad. Yeah, be back here at 4:05 for We Gotta Chase. I don't believe Creed's joining us, but it'll still be Florida Friday. But we'll see Creed for our members only. If you'd like to become a member, click the join button for as little as $3 a month. You can help support us. So if we get like 1,000 of you pledging $3 a month, we'll be good. That's all we'll need. That's all we'll need for at least a couple of months. Until next time.
Isn't happy hour anytime?
It really is. Good day.
Stick your show in your ass.
Now, I don't do drugs, though. Just weed.